Our meeting is now streaming live on YouTube. Good morning, everyone. In today's national level webinar on viability of e-courts post-pandemic scenario, I hand over to Principal Madam for welcome speech. Madam, please.
Vaidya, Principal Gokhale Education Society, College, Maharashtra. This college has been established in the year 1969, and we are now standing with 50 years of experience. This college has given many lawyers, judges, political leaders, social workers, and teachers to the society. This college is known for discipline, administration, excellence, infrastructure, and is famous for innovation. We conduct seminars, workshops, conferences, autonomous certificate courses, short-term training programs, and legal awareness camps. We have conducted in the year 2019, making legal awareness in society as a part of centenary celebration of Gokhale Education Society. The is famous remarkable extension activities along with academics. The is the pioneer in arranging and judgment writing in our college. We are conducting 2 courses, 7 diploma, and 1 PG course affiliated to Pune University, along with 2 courses in law. The college is NAC accredited in 3rd cycle very recently. We are conducting activities because of the continuous support, guidance, and motivation from the able leadership of our society. Secretary and Director General of Gokhale Education Society is a person with vision, having as a youngest with longest tenure, outstanding internal management scientist. He is bestowed with more than 85 prestigious awards in his account. On this occasion of national webinar, I welcome Honorable Sir Dr. M.S. Gosavi, Secretary Gokhale Education Society, Principal S.B. Pandit Sir, Chairman of Gokhale Education Society, and all the respected directors and members of the society. Friends, as we know, the entire country is facing outbreak of justice in time. Virtual courts is a good solution. The concept of virtual courts was conceptualized on the basis of national policy and action plan for implementation of information and communication technology in the Indian Judiciary 2005. It looks that it is a need of an hour to have ICT enablement of courts to make justice delivery system speedy, comfortable, and affordable. But how much it is viable in India is $1 million budget, techno-based orientation of judges and lawyers, process of e-filing document management, judicial knowledge document, e-payment, providing designated services to litigants, lawyers, and the judiciary by universal computerization of district and subordinate courts in the country, and many more are the issues. Therefore, we decided to have webinar on viability of e-courts in India post-pandemic scenario. Today, we're happy to have with us the Honorable Justice ManishPitale sir, Judge, Bombay High Court, Nagpur Bench, Nagpur, as a keynote speaker. Having graduated from Hindu College, University of Delhi, and completed LLB from Faculty of Law, University of Delhi, he enrolled as an advocate in 1995 and started practicing at Nagpur. Thereafter, he started independent practice in the Supreme Court of India in 2001. He appeared in a number of petitions and appeals pertaining to the field of constitutional law, arbitration law, commercial matters, civil and criminal cases. He was the panel counsel of the state of Maharashtra before he on behalf of Gokhale Law College. The judges So you can start now.
Yes, good morning, everyone. Dr. Vaidya and the participants on webinar today. First of all, let us hope and pray that the width is enough and we can see and hear each other properly. As we know, the topic for discussion today is viability of e-courts post-pandemic scenario. Now, the very fact that we are discussing this topic shows that the pandemic having hit us and humanity has shaken us to the roots and has affected our known way of life. Justice dispensation system is a part of the way of life. And therefore, this topic has suddenly become very significant and important for all of us. But before we discuss as to what would be the viability of e-courts in the post-pandemic scenario, we need to first take a brief overview of the manner in which the introduction of e-courts has been attempted in our system, and what are the efforts that have been made in the past, and what is the stage at which we are today when the pandemic hit us, and suddenly we are in a fast-forward mode to move into the e-courts scenario. If we look back, E-Committee for the Judiciary was established way back in the year 2004 under the aegis of the Honorable Supreme Court. It was found that with time and the advent of technology, even the court system will have to adapt and adopt such systems that would help bring efficiency, objectivity, and transparency into the system. That is the reason why in 2004 the committee was established, and till date there have been two phases in which the development of projects under the E-Committee has taken place. The first phase was, of course, computerization in a big way of all the courts, right down from the Supreme Court to the district courts. Now, considering the size of our country and the large infrastructure that was supposed to have been established in the first phase, that itself was a daunting task. That was undertaken, hardware was established, initial software was also introduced, websites of various courts were created, initially of the 21 high courts, and thereafter for the district courts as well, with the intention of integrating the justice dispensation system through these projects. The second phase was a little more ambitious, where it was thought that e-courts ought to be brought into practice, with at least one court in every high court being designated as an e-court, and attempts being made to connect jails with courts, district courts, sessions courts, so that remand matters could be taken care of in a given case, to record evidence through video conferencing, etc. Now, it is at this stage that we are when the pandemic has suddenly hit us, and we are exploring the real possibility of introduction, viability, and functioning of e-courts as a way of life in the justice dispensation system. Phase 2, in fact, if you go on to the website of the e-court services established for the courts, you will realize that there is a national judicial data grid that has been established. There are attempts to introduce a concept of GPRS, GPS systems into service of summons, because if a study is made, about 1/3 of cases are pending in various courts because service has not been completed. Now, this is a procedural aspect which is hampering the system, and introduction of technology in this aspect in phase 2 is found to be one of the crucial aspects. But it is realized in phase 2 itself that the present infrastructure that we have is perhaps not enough to support the ambitious goals that we look forward to. Therefore, in the third phase, it is expected that there would be introduction and migration to the cloud infrastructure, greater and better connectivity, leading to the ultimate object of a virtual court, or e-court as it is said. E-court in its absolute ultimate avatar will be a paperless court. The entire phenomenon of filing papers, having paper books of various sizes will have gone, and everything will be in the form of electronic data with the court as well as the lawyers and the litigants. Now, that being the ambition, ultimate goal, we have to realize that today we are in a situation where e-courts, at best, even in the high courts where at least one court is designated as an e-court, is more a concept of curiosity, a phenomenon of curiosity for the litigants and the lawyers. And perhaps no one till date, till the pandemic hit us, really took the e-court seriously. I can tell you from my own experience that although the kind of beginners e-court I have been conducting for the last more than 1 year, it is not a new phenomenon. I remember while I was practicing in New Delhi, that I had appeared before the court of Justice Muralidhar more than a decade ago, where he was actually conducting court through what can be called an e-court. The inclined platform on which paper books are kept by judges was replaced by the screen in Justice Muralidhar's court. All the documents, petitions, affidavits, and relevant material were in the form of electronic data in the screen in which the learned judge was looking into and interacting with lawyers. For me, it was a moving tribute to the advent of the e-court and the steps sought to be taken under various phases of development under the e-committee. More than a decade later, when I myself was assigned an e-court in the High Court, I realized that in addition to the traditional papers, paper books, and the traditional form of conducting court, there was a screen kept next to me, which I could use for conducting an e-court. Now, since there is always a resistance to change, I can honestly say that I did not start from the word go. From the first date as an e-court, I did not replace my paper books with a screen in front of me. I did try conducting a few matters here and there. And for me, it was more of an experimentation. Till About 2 weeks into the assignment on a weekend, I thought, let us take up the challenge. The registry of the court provided all the cases of the day along with the cause list, that is the list of cases listed on a particular day, in a pen drive to me. And I had to only slot the pen drive into my laptop and then access the material for self-study before conducting court on the next day. When I took it up, I realized that most of the features are user-friendly and that there is no great difficulty in conducting court in this manner. So I did start from the next Monday, and then I continued throughout the balance time period of the assignment. I realized that my efficiency, my speed, my understanding, my coordination in the court was not adversely affected. And in fact, in certain aspects, my efficiency had improved. But I realized that litigants as well as lawyers were entering my courtroom, those who didn't have cases listed before me, sometimes out of curiosity to see what is this e-court? What is this screen that has replaced the paper books in front of this judge? They would perhaps walk out of the court and not give a second thought to it. But when my assignment changed, and since I found it very convenient, I requested the registrar to continue the same system in my next assignments also. Now it has been more than a year that I have been conducting court in this manner. I still call it a beginner's e-court insofar as I am concerned, because there are certain difficulties I have been facing. I have been trying to solve them with the technical staff, but I've not been able to find satisfactory solutions to that. But much of that later. All said and done, I have tried for the past more than 1 year to conduct court in this manner. The lesson that I have learned is that even if I am doing it at my part, there are other stakeholders in the system who are yet to come on board. The council are still not, the lawyers, advocates council are still not comfortable with they shifting to the ideal concept of e-court. I don't see them using iPads, tablets, data in electronic form while arguing matters. They are continuing with their traditional paper books and the method that they have been using for years. So other stakeholders are yet to come on board. Although, at least insofar as my court is concerned, I found that some of the council have gone beyond the stage of curiosity and genuine interest in the concept of e-court has developed. It is at this stage where some courts in various high courts are conducting beginners e-courts in this manner that the pandemic has suddenly struck us. As I mentioned, it has shaken us to our roots, and we are now having a rethink as to how to kickstart the system. Because with the extreme restrictions that have been brought into place because of the physical distancing that is required, because of the fact that it is required that the persons ought not to get in touch with each other, they ought not to touch surfaces from where the virus can infect them. There are extreme restrictions leading to the system almost getting paralyzed. But considering the huge burden of pendency and the crucial role that the justice dispensation system plays, there has been an attempt to revive the system even during this pandemic. Although courts have started functioning in a very truncated form, maybe perhaps only 5% of the courts are functional under video conferencing and a virtual interaction between the council and the court. But serious thought is now being given to the concept of e-courts. Till date, since it was more in the level of curiosity, the necessity to develop the infrastructure was also not found to be an emergent need. with the pandemic having hit us, all of us have been, in a way, fast forwarded into this concept of e-courts. And as I mentioned, this is perhaps the occasion to have the webinar today on this topic. I find that with the predictions that are made about the pandemic, it is here to stay with us in the foreseeable future. There are statements that there would be a second wave or even a third wave of the infection, and that the pandemic is not leaving us in a hurry. The race to find a vaccine is also underway, and one doesn't know when it will come. And therefore, in the foreseeable future, we are faced with the emergent situation that we are facing right now. Due to this, there would be discussions on putting in enough funds to develop the infrastructure. And we would perhaps have this as one of the positive fallouts of the pandemic having hit us. But the real topic today is what happens when the pandemic is over? In the post-pandemic scenario, will we go back to our old ways? Will we go back to our traditional ways? And will we then again treat e-courts as a matter of curiosity and always feel that e-courts being a reality is something in a very, very distant future? I believe that the only lesson we must learn from the pandemic is that in the post-pandemic scenario, we ought not to go back to our old habits. We will have reached a stage where we cannot look back. But at the same time, we need to analyze in a realistic backdrop as to whether we will really, in the post-pandemic scenario, replace all the courts as they today function with e-courts from the stage of filing to the stage of disposal of cases. I believe that a realistic assessment would show that even if we aim for that, even if that is what our ultimate ambition is, our ultimate goal is, the stage of development of the infrastructure today will not be able to support such an ambitious goal. Development of infrastructure, migration to cloud infrastructure, fast connectivity would be of necessity for e-courts to be introduced at such a high level of proficiency that the courts would literally become paperless courts. Now, if that be so, would it be wise to ignore development of infrastructure and go back to our traditional method? I believe we need to take a look as to what are the advantages of e-courts, how the e-courts in combination with the existing system can provide the best possible alternative for the litigants for whom the entire system exists. The litigant is looking for an efficient disposal of cases, is looking for inclusiveness, is looking for sustainability, and is looking for faith in the system. If we analyze the manner in which courts have been traditionally conducted in our system over the years, there is no doubt about the fact that it suffers from delays. It suffers from sometimes even lack of faith of the litigants in the system simply because of the number of years that a case takes to reach its finality, and that I believe all the stakeholders in the system are responsible for the state in which we find ourselves today. Introduction of technology, introduction of facets of e-court would certainly bring about a change. They would lead to efficiency. Introduction of technology would reduce intervention by humans in the processual aspect, which is very crucial, because a software will not differentiate between litigants. It will reduce the chances of a particular litigant taking a march over another on the processual side, on the side of processing of cases to be taken up for hearing by courts. The complaint often made that certain category of litigants get a preferential treatment will be reduced to the minimum by introduction of technology, which would in turn inculcate faith and trust in the litigants. If the procedural aspect is taken care of by technology and other aspects of e-courts, efficiency will increase and cases will reach the stage of hearing before courts in a much faster manner. Therefore, we need to, in the post-pandemic scenario, marry the advantages of technology with the existing traditional way of doing things, instead of suddenly jumping to replace the traditional courts with e-courts. Now we need to, in brief, look at in what manner can technology be introduced from the stage of filing to the stage of disposal of a case. E-filing has become the norm in the pandemic period. Cases have been filed through email by lawyers. They have been registered on that basis. They have been placed before the courts in that manner. Counsel has been heard through video conferencing. Orders have been passed, which have been uploaded on the same day and emailed on the same day to the lawyers and parties. And therefore, it is evident that even in the absence of physical filing, the functioning of the courts is not hampered. E-filing, the first phase of interaction between the litigant and the system, is filing. E-filing is certainly now introduced in a big way in the court system. Next comes the processing of matters, the removal of objections or defects in certain courts, which can be notified to the counsel directly on the websites, which can then be cured there itself, and the matter can come up immediately for consideration before the courts. The crucial aspect of difficulty in service of summons, as I mentioned earlier, is one of the reasons for large amount of pendency. This can be taken care of by introduction of technology. Now, how many of us know that in phase 2 of the projects of the E-Committee, there is a concept called NSTEP, that is the National Service and Transaction of Electronic Processing. It is sad that most of us are not even aware of this. This is a technology which can be taken up in mobile applications and which can be used by bailiffs while serving summons, which is supported by GPRS, GPS systems, and coordinates are recorded when the service of summons is completed. And such electronic data gets transmitted to the court, making it part of the court of the record for proof of service. Therefore, the chances of avoidance of service, misstatements being made, misleading statements being made about service of summons can be taken care of in a very efficient manner. Then comes the stage of recording of evidence, remand matters, connecting jails with courts through video conferencing, which has been already undertaken in some courts in our country, has shown that remand matters can be taken care of very efficiently. Recording of evidence through video conferencing reduces chances of adjournments and enhances the speed with which the progress of cases in courts takes place. Counsel, if they find it very inconvenient on a particular day to be physically present in court, can be heard through video conferencing, thereby again avoiding adjournments. And finally, At the stage of deciding the cases, written submissions can be additionally submitted through the electronic medium by the counsel to the court, which can be taken into consideration, and cases decided, orders and judgments put up on the website instantly. So from the stage of filing till the stage of disposal of the case, technology plays a crucial role. We cannot ignore the fact that technology has already entered our doors. The question is how best we can utilize it in the post-pandemic period. As I said, we ought not to go back to our old habits. We ought to combine the existing system, encourage technology, and try to serve the litigants as best as we can. In this backdrop, you must have seen news items about virtual courts. In fact, today's newspaper reports that a virtual court, insofar as traffic challans are concerned, has been introduced in Pune yesterday. The first such court was introduced in Delhi in July 2019, where a computer generates challans for traffic violations. These challans are communicated to traffic violators through SMS, and in this message, an e-payment portal is also given, which the violator can access and make payment of the challan. Now, crucial time, valuable time of judicial officers, magistrates is saved in this manner of virtual courts. This is a phenomenon which has been introduced gradually, and it will take over insofar as repetitive work is concerned. Then we come to introduction of the new interface of filing, e-filing in the Supreme Court, which was inaugurated yesterday by the Honorable Chief Justice of India, Justice Bobde, and Honorable Justice Dr. D.Y. Chandrachud, who is chairman of the E-Committee of the Supreme Court of India. While inaugurating the dashboard, as they say, of new e-filing system in the Supreme Court, the technical expert explained in detail as to how the interface is user-friendly and how it can be used for efficient filing, not just filing, removal of defects, not just removal of defects, service of documents, and making the case absolutely ready when it comes for hearing before the court, which can also be a hearing through video conferencing. At no stage does physical filing of documents become a necessity. While inaugurating the system, the chairman of the E-Committee, Honorable Justice Chandrachud, did indicate that such introduction of technology, e-filing, and other such aspects of e-courts must necessarily pass the test. It was explained that test, T-E-S-T, represents 4 features of the system which the litigant is looking at, namely T being equal to trust, E being empathy, S sustainability, and T being transparency. It was indicated by the Honorable Chairman that it is when these aspects are incorporated that the real test of the system will have been passed. Therefore, efforts are being made all over, starting from the Honorable Supreme Court, to open up the system through introduction of technology at this stage when we are facing such a huge pandemic crisis. Having become used to this kind of system and slowly becoming aware of the advantages of the same, in the post-pandemic scenario, we cannot say that the e-courts will be again relegated back to just one designated e-court in the 21 high courts, and that it would again become nothing but an aspect of curiosity amongst the litigants and the lawyers. It is all the stakeholders in the system who need to take this aspect seriously. I am aware that today we are not having that kind of infrastructure, but the pandemic has shaken us into giving a serious thought to putting in enough funds to develop an infrastructure which will take care of the burgeoning needs of our legal system, of our justice dispensation system. Migration to cloud infrastructure is necessary. And the most crucial aspect is being able to ensure data security, being able to fight off hacking, and continuous maintenance that such a system would require, along with immediate troubleshooting, so that there is no impediment in smooth functioning of the system. I believe that in the post-pandemic scenario, the introduction of technology via the medium of e-courts would be here to stay. It would be very difficult for us to unlearn what we learned during the pandemic period. And it would be at our peril if we unlearn what we have learned. There is no going back. And for the present, till the infrastructure is developed in the way in which it ought to be developed, we will have to aim towards a hybrid system which takes the best of technology, combines it with the existing system of justice dispensation to give the most efficient, transparent, and inclusive system that we can to the litigants for whom we all exist in the justice dispensation system. The ultimate goal of having paperless courts, everything on a data, electronic data, is not in the immediate future, obviously. But if we aim high, we will be able to reach at least 70 to 80% of our ultimate goal. It is a challenge that the ultimate goal of a paperless court must also be all inclusive. It must not keep out people who are technologically challenged, people who do not have access to technology, people who are not literate, namely some of the litigants, and that systems are developed within the infrastructure which ensure that the system is all inclusive, efficient, transparent, and improves the justice dispensation system beyond what we have been seeing for a long, long time. I think change of mindsets is the first step. There is no point in saying that e-courts in their full-fledged avatar are in the distant future and not for our generation. We should not have that approach. Most of the litigants and the lawyers ought to break the mindset that going to court means an investment of about 2 decades of your life, that avoiding service, once having got interim orders, trying to delay matters and to take advantage of the system in such a negative manner, ought to be mindsets that need to be completely destroyed. And we all need to work for the efficiency of the system so that as litigants, all those who approach the courts find it to be fair. In this regard, I think that the younger generation of lawyers, students who are aiming to become lawyers, will play a crucial role. Technology will do away with exclusivity, and it is the younger lot who, with their comfort with technology, can make accelerated progress in the post-pandemic scenario, when technology would be here to stay and would play a big, big role in the justice dispensation system. It is this generation of the younger lot, which will power the system with technology, take it into the future, and perhaps in a decade or two, we will have reached the ultimate goal of e-courts in their final avatar, which do not tolerate inefficiency, promote efficiency, promote transparency, and ensure that justice for all as the ultimate goal of our justice dispensation system, justice for all with efficiency, justice for all with proficiency with fairness and all inclusiveness is achieved at the earliest. Thank you for the opportunity given to me. We can have the questions now. Thank you.
Have you got questions from principal madam? Hello, sir.
Yes, Mr. Sadbhai.
Sir, have you got questions from principal madam? Prior questions?
Yes, you want me to refer?
Yes, sir.
All right. As I see it, the first question that was forwarded by Dr. Vaidya was that e-courts would definitely assist in speedy disposal. However, given the rise in cases of cybercrime, e-courts would be susceptible to hacking. And how would we ensure safeguards to prevent hacking or tampering of data of e-courts? Now, there is my speech also that there is a serious concern about hacking. Once we try to migrate towards technology and we look at e-courts.
Short and specific questions.
But we have to be very clear that when we take up any new enterprise, it is always fraught with risks. Think of the first time when the automobile was invented. I'm sure people thought because it runs faster than cycle or people who walk on foot or run, it would be given to accidents. And therefore, it would be perilous. And should we then use automobiles or not? There would have been accidents, fatal accidents, which would have then discouraged use of automobiles. But we see today that they are part of life. So therefore, as technology develops, as infrastructure develops, as the hackers try their best to hack into the system, there is technology to fight hackers as well. So therefore, while we look for change, we have to go with this mindset that there would be risks, but we have to realistically analyze that are the risks so high that we should not go in for change at all. So I think there are risks, but there would be solutions as well. The second question was, what would be the authenticity of orders uploaded on the website? Now for this, there is a straight answer because one such question had cropped up in my court, where there was an earlier order passed by the court directing a particular party to deposit costs in the court below within a specified period of 2 weeks. Now, when the went to deposit the costs, the court refused to take it because the court said, get a certified copy of the order of the High Court. We will not allow you to deposit the costs. The risk that the litigant was running was that if he did not deposit the cost within 2 weeks, there was a default order by the High Court that he would suffer some adverse consequences. In this situation, certified copy not being available, the website order being provided to the court, an emergent application was filed in the court which came up for consideration before me. Now, I disposed of the matter by referring to an order passed by Aurangabad bench of the Bombay High Court by my brother judge, saying that there ought not to be any insistence on certified copies. So in my order, I have followed the order of the Aurangabad bench, and I have specifically said that none of the courts below will insist on a certified copy as long as a copy from the website, official website of the High Court is obtained, a printout is obtained and produced before the court below. It is only if the court finds it suspicious that it can go onto the official website, verify the correctness of the copy of the order and go ahead with the matter. And I have observed in that order that none of us can stop the march of technology. So that's the answer to the second question. The third is, what about procedure in cases of appeal where documents would be required to be sent from lower courts to high courts? Now here in the pandemic scenario, the Honorable Supreme Court has indicated this, that now that we have the National Judicial Data Grid and almost all the courts in the country are sought to be brought onto the grid, and the ultimate goal is vertical integration. We are soon reaching a stage where by a click of the button, you will have documents of a particular case right from the magistrate's court up to the High Court available for vertical integration and transmission to the Supreme Court of India. So if that happens, the difficulty in transmission of documents will also be taken care of. Next is, can evidence be recorded in civil and criminal cases through video conferencing? Yes, there can be no doubt about it. Such exercise is being undertaken. You would perhaps require certification, e-certification, etc., which would ensure the authenticity of such recording of evidence. There should be no difficulty in that. Let me inform you that Gadchiroli, which is one of the most backward districts of our state, that is a state where for perhaps the past 12 years, evidence has been recorded by video conferencing. So we have to change our mindset and not be in doubt about such things. Then comes, of course, whether virtual e-court system has been far more effective. Now, virtual, actually, we should now know the distinction between what is referred to as virtual court and an e-court. Virtual court is what was inaugurated in Pune yesterday and in July 2019 in Delhi. Those are courts where the computer is actually generating challans because it's just a repetitive kind of robotic function. Virtual courts are good for that. E-courts is a different phenomenon. E-courts is where the judge is presiding, but he's helped by technology like video conferencing, etc. So obviously you cannot replace a human judge in our system by a computer, because I have said that in an article which I wrote during the beginning of this year, that the concept of replacing human judges with computers is impossible, especially in our country where judges require not just cramming of data or knowledge of judgments that are available, but also a sort of emotional competence to be able to really sensitively understand the problem of the litigant and to place the scales of justice in such a manner that fairness is ensured. So therefore, yes, we will have virtual courts in a big way, but e-courts will still be presided by human judges of competence. Then the next question is whether the present infrastructure and system are sufficient to meet the functioning of virtual e-courts. Yes, for virtual courts, they should be enough. But as I mentioned, for the e-courts, we need to migrate to cloud technology, cloud infrastructure. A lot of funds need to be put in. The system needs to take care of the development of infrastructure. And for achieving the ultimate goal of a paperless court, it will take some time and infrastructure is yet to develop. I must tell you that when I argued, as I said before, Justice Muralidhar in Delhi High Court, I was surprised that lawyers who had just entered the bar were referring to their iPads and tabs. Their files were in those electronic mediums. They were referring to pages there and arguing. That is perhaps the ultimate paperless court we are looking at. But that is sometime in the future. Yes, any more questions? Any more questions?
No questions, sir. I want some explanation from you that to use this technology, is there any need to form a code of conduct?
Yes, I'm sure on the technological side, it would be the technicians who would be able to guide us. I'll tell you something very basic. When I first sat on a video conferencing court during this pandemic scenario, when assignment was given to me, the technology assistant had to tell me that look at the camera and interact, because I was in the habit of looking at where the lawyer was on the screen. So they're very basic, but then this is something which we need to incorporate in our conduct. The other, of course, is that what happened horribly in proceedings Rajasthan High Court, where a lawyer was found to be wearing only a banyan, appearing in the virtual and video conferencing court. That ought not to happen. Discipline ought to be followed. Formality of the proceedings ought not to be given up. And misuse of technology ought to be curtailed through proper code of conduct. Of course, this is something which we will learn on the job. Yes.
Thank you, sir. I think we are not taking any more questions. On behalf of Gokhale Education Society, NB Thakur Law College, and all organizing committee members, would like to say thank you, sir, as you took your valuable time to appear in front of we all on this virtual floor, and you guided us on various things where technology is best possible alternative for efficient disposal of cases in post-pandemic scenario. Then you also have guided us on that e-filing is become a routine practice and norm set during this pandemic. Therefore, the process like summons of service of summons with GPS for all these things, I assure that with your session, everyone will think on it that we must be uh, technology conversant, familiar to use technology while doing court work. Then digital literacy is very significant issue that though there are certain infrastructural restraint, still in post-pandemic scenario, we all should be there to face all these challenges and try to find out way to use technology for betterment of litigants and all judicial system to dispose various cases and to help judiciary. Thank you from my part. As all participants across India participated in our meeting, in our session, national level webinar, I must mention our deep sense of appreciation to them for attending full time this webinar. Thank you so much for inspiring us and guiding us. Thank you again.
Thank you, sir. Thank you very much.
I will play national anthem, then end our meeting.
Yes, yes.
Let's all stand up. उच्चल जलधित रंगा तव शुभ नामे जागे तव शुभ आदेश मांगे गाहे तव जयगान Thank you.
Thank you. Thank you all. काय ग का बरं तू म्हणलं हे कर नाही तू का म्हटलं मला काय की बंद कर 2 मिनिटं बंद करायचं ऍडजस्ट करायचं आणि मग ऑन करायचं